Right. This case is set for trial tomorrow, I believe, on a Class C misdemeanor. Mr. Miller, you understand that you have requested a trial and I have assigned a trial date tomorrow for your case. You understand that?
Yes.
All right. And you are charged with a Class C misdemeanor. And you understand that a Class C misdemeanor doesn't carry any jail time. And therefore, it will have to be a bench trial. It won't be a jury trial because you are not entitled to a jury trial or to appointed counsel where you are charged with a Class C misdemeanor, which is only, you can hire a lawyer if you want one, but I can't appoint one for you because you're not facing incarceration in jail. You're facing a fine would be the only punishment that can be given if you're found guilty. You understand that?
Yeah, I understand that.
Okay. So are we ready for trial tomorrow?
I thought he had requested an attorney.
No,
I'm so
I done
confused.
seen
I'm so
two
sorry.
attorneys.
Pardon?
I've done seen two attorneys,
Okay.
and one's 5,000, the other is 10,000. And so it's a $50 fine. That's not the point. I'm not going to pay the $50 because what I'm charged with is not right. What the code that got me charged with, I was on my own land.
Your Honor, the state had filed to continue. I thought he had filed for an attorney based on our conversation last week, and was hoping he would get one. He actually has another violation pending that was just sworn out this Friday, Your Honor, for hunting without a permit.
It's easy. Now, I told you a couple of weeks ago that I done seen two attorneys. We're going to get another attorney. In the beginning of the first trial, this is going on 2 years. I've been here 3-4 times a year ever since the 1st of August 2 years ago. I don't even know what evidence they got. I haven't been told anything. I haven't been read my rights. I don't know nothing except the person that took a video of me unloading sewage on my property, took a video, and I've got holding tanks out there that I use to unload my sewage in, because about 6 months out of a year, it's the only time I can get my truck out in the middle of 30 acres where I can spread it on 1 acre of ground. And so everything I've been charged with up underneath that code is actually obsolete. And the person, Jeanette, that's over this one, and I think he's a new guy. Anyway, he was one that sent me, and Jeanette sent me a certified letter about a week or so before this one did. It said if there's any discrepancies or anything that you need to say, call this number. And I called him 4 or 5 times. I got a hold of his secretary, and every time I'd call, he wouldn't be in there. And she said, well, I know one time, she said, well, I know he's in there. I just seen him walk in the office. And so I called him, and finally, after several phone calls, and then after she called me back, I finally talked to him, and I told him I've got two individuals down here that supposed to be checking my land, and Clarksville was in charge of it for the last 20 years. And all of a sudden, Clarksville, they closed Clarksville down, and nobody didn't notify me that Nashville was the one that was taking over it now. And I've got all kinds of papers where when I got a permit when it was dry enough for me to get out there on my land. I've got about 13, 15 years of paperwork where they was sent back as far as October before I got the permit for that year instead of January the 1st, because I couldn't use and still can't use that land. And I got also that same year that I got the certified letter, I got 5 different times that I got pulled out of that pump truck trying to get back there in the middle of that 30 acres to spread that sewage the way it's supposed to be spread. And so I don't know what he's got, but whatever it is, that's the reason I want a 12-man jury.
All right, let me just say this. I misspoke because I wanted to double check, and you're charged with a Class C misdemeanor, but it does carry under the statute a sentence of not greater than 30 days in jail or a fine not to exceed $50 or both. So as a result of that, it is a case that he would both be entitled to appointed counsel if in fact he is indigent, and it would also involve a jury trial rather than a misdemeanor bench trial. So are you requesting that I consider granting you an attorney because you're unable to hire your own?
Yes.
Now I want you to raise your right hand. I'm just going to place you on oath for the purpose of filling out an affidavit of your income and expenses for me to determine whether or not you are qualified to have a lawyer appointed, okay?
Okay, I've done read that paperwork on and I wouldn't be qualified for
All
it
right. Then,
unless I sold a bunch of property.
so you own property and as a result, you would not be qualified. All right, then he's not entitled to an appointed attorney. You had indicated that you've talked to 2 different attorneys and that the cost of hiring an attorney was exceeding what you felt like you wanted to pay. Is that correct? All right, so you're confident, you feel like you want to represent yourself at this trial?
Yes, I want to show evidence. First of all, I want to see the evidence that's charged against me. I haven't even seen it.
Your Honor, the state was hoping that a counsel would be appointed today, because if they are appointed, I'm going to move for a competency evaluation. I don't think that evaluation will happen unless there's counsel there to assist.
Well, he's not going to have an attorney appointed for him because he's not indigent, and therefore he has declined to hire an attorney because of the cost involved. But as he stated, he owns property and therefore would not qualify for an attorney to be appointed. So for that reason, are you telling, is the state not ready to proceed on the case?
They are ready.
Then we will try this case to a jury tomorrow. We need a jury. All right. We will see you here at 9 o'clock for your jury trial.
Okay.
All right. Thank you.
Do I have to be here for this?
Hmm?
Do I have to be here for this tomorrow?
No, not for a misdemeanor.
Good, because I'll be working for Kim tomorrow in Champion.
Who do you work for?
Kim, or Judge Wallace in Champion. So I, okay, just wanted to make sure.
2025-052, State versus Darrell Ray Tanner, Jr.
Your Honor, this is my motion to withdraw due to a conflict on this case.
All right, and your conflict is with the alleged victim in the case?
Yes, Your Honor, we represent her.
We have a 20 list. Well, we'll appoint Mr. Jay Runyon to, since he got some special treatment this morning, we'll appoint Mr. Jay Runyon to represent this defendant. So this is the no good deed goes unpunished rule. So All right, we'll appoint Mr. Jay Runyon. Let me step off for just a minute. And Joe, let me speak to you. All rise.
Good to see you.
They gave me a message for me being late.
Yeah.
Okay.
And I saw some of the movies, the house. I saw two.
We did put in a transport order.
If he's anywhere, he'd be.
Yeah, yeah, I think I saw their van out front.
Yeah.
I feel confident.
So you must have left out. Still in here. He's in the back end for. We're going back in.
They're very. Yeah.
Prayer on the side of caution.
I got it. Figure there. Were you here? Yeah.
Yeah.
I could try.
Yeah, it went.
Yeah.
He did sessions, I think, 2 seconds. Because he got their property hearing, or them like, he didn't even put on any proof of something, he got there and made one, he did it. And then in there, so. Yeah.
I'll just sit there, 'cause I want to know where I can go.
No, that's the problem. I had a guy.
There's no
I'm not gonna leave back on the door. Everybody's to the door. I don't know, Sheriff might tell one of us about that.
Okay.
All right, let's talk about that. Judge David D. Wolfe ran a careful, quietly fascinating docket, and the standout was the colloquy with Corbett Miller, one of those moments where processed patience and practicality all meet. Wolfe began by framing the stakes on what everyone thought was a routine Class C misdemeanor, then immediately corrected the record. Yes, it's a Class C, but it carries potential jail time, which means 2 big consequences: legibility for a jury, and if indigent, eligibility for appointed counsel. That mid-hearing course correction is classic Wolfe, measured, transparent, and squarely grounded in statute. From there, he walked Miller through the realities: no appointed lawyer if you're not indigent. A jury panel will be assembled, and we're trying this case tomorrow at 9 a.m. Miller, for his part, was animated but not disruptive. with Costs adamant about defending himself, and eager to view and present evidence about permits, land use, and how his own property factors into the charge. He said outright he's seen lawyer quotes for thousands on a case that could carry only a small fine, and you could feel the sticker shock driving his choice to go pro se. Wolfe stayed steady, verified assets, and, once it was clear Miller didn't qualify for appointed counsel, set the jury, and kept the train moving. The state floated a competency evaluation if counsel were appointed. Without counsel, they stood ready to proceed, and Wolfe marked the calendar. That balance hearing Miller out while keeping the focus on what the law actually allows typifies Wolfe's bench style. Firm, fair, and unflappable. Beyond Miller, the room had its quick pivots. After the Miller scheduling, a separate matter popped up where defense counsel sought to withdraw due to a conflict with the listed victim. Wolfe granted the request and appointed replacement counsel with a wry, no good deed goes unpunished, a side-dry humor that lightened the tone without undermining the seriousness. Back on Miller, the body language told its own story. He was resolute, almost eager to have his day, and repeatedly emphasized he hadn't seen all the proof against him. The judge responded with process, not push back jurors tomorrow. Evidence at trial, see you at 9. No one looked flustered. The prosecutor stayed on task, confirmed readiness, and avoided theatrics. The overall atmosphere was calm but kind of quiet tension that comes when a self-represented defendant insists on a jury and the court must thread the needle between autonomy and orderly procedure. If there was an oddity, it was the contrast between the small maximum fine and the large private fee. Quotes Miller reported. Still, Wolfe didn't minimize Miller's concerns. He just kept returning to the rails of the law, indigency standards, the right to a jury when jail is possible, and the responsibility that comes with representing yourself. Bottom line, a tidy clinic in judicial housekeeping that still felt human. Wolfe corrected the record, protected the rights in play, and set a clear path to verdict, while Miller, unhappy with the economics of counsel, chose to stand and fight in front of a jury. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.